So, you just found out you're going to be an executor. This is a very difficult and time-consuming job, but there are some things you can do to make your life a lot easier. We happen to have a checklist for this. It's in References, and it's the beginning of the estate process. Your before death checklist. You need to sit down with the person that you're going to be the executor for, and they actually need to help come up with these lists for you. Having gone through this process, I can't even emphasize enough how important this is. If the person is not willing to work with you on this, because they think the information is private, you have, as far as I'm concerned, three choices. One, they either work with you and come up with the information and you become the executor. Two, they can not work with you, but they can come up with the information on their own. And then they can store it in a safe place where you as the executor can access it later. Or three, the best way to do this if they are not willing to work with you is just to refuse to be the executor. Let the lawyers deal with it. Let the state take the entire estate. The state take the... Hey, that's a tongue twister. Let the state take the entire estate, because it's not going to be worth your time, effort, and your personal life to try to deal with this after they're gone. Okay, item 1. Make a list of significant assets and keep it current. Let's take a look at what significant assets are. Before death instructions. Significant assets are all your available money. Checking accounts, saving accounts, certificates of deposits, ATM cards, sources of current income. I mean all the sources of income, because you're going to have to know this, including a pension, retirement accounts, Social Security, military, stocks and bonds, commodities, real estate. How many different homes you own, vacation homes, rental properties, timeshares, agricultural. Do you own an airplane? I mean, does he or she own an airplane? The business interests that the person is involved in. Do they have partnerships, corporations? Copyrights and patents. Sometimes that's a significant source of income if you're a really creative person. Motor vehicles, motorcycles, boats, planes. Home inventory valuables. Okay, this is a big one. As the executor, you're going to be required to come up with an inventory of everything that is in the house and everything that that person owns and submit it to the court for probate. And that is a significant amount of time required. For example, let's take a look at home inventory. All your bedding, books, collectibles, computers, garden equipment, guns, pets, photographic equipment, religious items, sports, tools. You're starting to get the idea. You as the executor has to come up with all this information, and it's a lot easier for the person that collected all that stuff to know what they have and write it down. Okay, we'll cover the rest of this information a little bit later. You want them to write a simple, clear will, perhaps a simple living trust. The reason for the living trust, no, that's way too deep for this subject. So let's cover the simple, clear will. Your will is going to cover things like the disposition of property that you own, like who's going to get what. Instructions for burial. Do you want to be cremated? Do you want to be put on a raft and sent out to sea? Etc., etc. Care of minors or pets. That's pretty important. Don't forget the little furry ones. If you die with no will, only surviving spouses and lineal, I believe that means blood, is eligible to inherit property. You might want to cover information like people to notify, child care requirements, animal care we've covered, care of your property, things that have to be done to keep property, like water my plants, stuff like that. Okay. If you die with no will, the state takes over. And the state will assign the executor in this order: your surviving spouse or spouse nominee. Remember, you don't have to say yes to being an executor. It's purely voluntary. So they can't tell you have to do it. Then other kin, remember their blood. Then the county administrator would take over. And remember I said the state will take everything? Or if the state doesn't want to do it, then any creditor of the deceased after a certain time period can take over and basically get everything. So to wrap up this little will thing, please make sure there's a will. If there is no will, and you live in any of these states here, the Uniform Probate Code will very clearly define what happens to each and every article of that estate. It says who gets what and everything, and you as the executor will just wind up spending a lot of time in court listening to the judge tell you what to do. And if you don't live in one of these states, it's a coin toss as to what's going to happen. Each state will have their own rules. Item 3. Hold as much property as possible in ways that will avoid probate. What probate is stuff that the court is going to get their grubby little hands on. Let's take a more detailed look at what I'm talking about. I'll go to References, Estate, Property Types, and Kinds of Non-Probate Property. Common kinds of non-probate property. Now keep in mind that this is all not necessarily going to be true, but generally speaking, joint tenancy property. If you own something and somebody else owns it with you 50-50, the other person moves in and it's not subject to probate. Tenancy by the entire property, don't know anything about that. Community property with rights of survivorship. Living trust property. Living trust basically means you've already done all the legal work, so the courts have already been involved. Real estate that qualifies as a homestead and passes automatically to the spouse or the children. That sounds complicated. Household goods and other properties that go immediately to family members under state law. Wages, salaries, or commissions due to the deceased person. Payable on death bank accounts, commonly called POD. You'll also have another one called TOD, transfer on death. And this basically means the account belongs to the person that's living until the day they die, in which case it legally is transferred over to another person. You can accomplish the same thing just by making the person joint tenant on the account, but for those people that want to keep all their stuff, specifically their stuff, this transfer, where to go, life insurance payable on death bank account is the way to do it. Life insurance proceeds because the life insurance has a specific person called out in it. Retirement accounts, securities registered, and transfer on death. Well, there's that TOD I was telling you about. Savings bonds if co-owned. Basically, if anything's co-owned, it sounds like it's not going to be probate property. Vehicles registered and transfer on to TOD again. Vehicles that go immediately to family members under state laws. Pension plans. Money in health savings accounts with a named beneficiary. Are you starting to see something in common with all of this? There's already a name called out legally for all this stuff. And the last one is personal property in small estates. A small estate is defined by each state as an estate that is below a certain dollar amount. They don't even want to deal with taking it to court. So if you basically, they're saying if you don't own anything, we're not going to go to probate. Set out final arrangement wishes in writing. Now this may sound like they're talking about the will, but this is actually into more detail. Final arrangements is covered in the will, where you want to be married, cremated, etc., etc. But there's a lot more detail involved that you can get involved in. Let's go to References, Estate Processes, Before Death Instructions, these 4 pages right here. There's going to be a letter of instruction. People you'll want notified immediately upon your death. Once a person dies, time is your enemy. A lot of stuff is very time sensitive and has to be accomplished immediately. Oh, good example, childcare. You probably don't want that child to go for more than a couple days at the most without being fed or watered. Stuff like that. But let's take a look. You can create a letter of instruction. We've already seen this once already. And you can, in detail, state exactly what has to be done with each and every item on this list. And that's reserved more for a letter of instruction versus a will, because the will is something that the court's going to have to hang on to. And the more detail that you put into the will, the more the court's going to stick their nose into it. So the will could say, for example, I want my beneficiary executor to handle my estate according to my letter of instruction. And that information will be here, and you do your thing, and the court will know that you're just following the rules set forth by the letter of instruction. Item 5. Make sure documents such as the will, tax returns, deeds, insurance policies, and so on are accessible to the executor. We're talking about your executor not only has to have access to it, for example, put it in a safe, a safety deposit box, store it in, I don't know, your car's glove compartment, make sure it's locked, but make sure your executor knows where it's at. And you also want to make sure that other people cannot gain access to those documents. So I guess we're going to have to back off on the car's glove compartment box. Let's go back to safes and stuff like that. Because other people that may not be quite as honest as you are may get in there and try to make changes to some of these insurance policies and deeds and wills and stuff immediately after the person you're executoring for has passed on, and that's going to cause quite a bit of trouble. For example, we had to be the executor for a relative. That relative had a person living with them. That person knew the combo to the safe. As soon as our relative died, that person got into the safe, stole the will, and since we tried to find the will, we couldn't. We tried to become the executor. It was extremely difficult without a will, and it drug on for an extremely long period of time before we finally make final arrangements and close out his estate. Make sure your executor will have access to passwords to important accounts. This actually is a really big one in today's digital world. Think about how much of your life is currently in the digital domain. You have things like your bank account, finances for retirement, utilities, entertainment, things like Netflix and Hulu. There's news feeds, shopping accounts such as Amazon, social media, Facebook and others, your phone, your actual internet itself, email, government accounts, taxes, Medicare, even your library could be online. That's a lot of passwords. Every single one of these accounts are going to have their own rules and regulations on how a person who's an executor will be allowed access to the account, or whether they won't be allowed access to the account. And it'll take you a lot of time and effort to get access to all these accounts. And if you have a password, that's the starting point. Now, the other thing you need to think about is identity theft. Once a person is passed on, they are the prime opportunity for identity theft, because the identity thiever thinks, well, who's going to be fighting me? And I'm not going to be hurting anybody. But that's going to make your job as an executor much, much harder. So the first thing you need to do, well, one of the first things, is contact the 3 big credit bureaus, report their death. More than likely, they'll require a death certificate. I'll show you how to find that later. And have their credit histories locked up so nothing else can be opened up in their names. Item number 7. If he or she owns or might own after the death of a spouse assets worth more than $5 million, investigate a way to avoid federal estate tax. This changes year by year how much the value is, but once the federal government says you're worth $5 million, they want their share. Let's take a look at what we're talking about. Estate taxes. Valuation of gross estate. Deductions, federal income tax. There we go. So this particular book that I pulled this copy out of says the federal estate tax applies only to estates with assets exceeding $5.25 million as of the date of the death. This year could be different, but Most of us that'll be listening to me talk aren't even anywhere near $5 million, so you probably don't have to worry about that. If the estate will contains hard-to-sell assets such as complicated investments or a family business, make a clear plan for the executor to follow. Okay, what's the English version? Let's go to References, Estate Processes, Instructions. Okay, here we go. Business interests. I don't know about you, but I know absolutely nothing about sole proprietorship, partnerships, limited liability companies, corporations, etc., etc., etc. So, since you're going to be the executor and the person that you're executating for was doing any of this, they need to be able to tell you how to deal with this stuff. If they don't tell you how to do that, your only other alternative, my guess would be, is to hire a lawyer to take care of it for you. And lawyers, believe it or not, cost a lot of money. Item number 9, get a handle on debts. I'm hoping, and you're probably hoping, that there will be a list of all the money that is owed by the person that's deceased, and that'll make your life a lot easier. Unfortunately, just the mere fact that you've died doesn't get you out of your requirement to pay a debt that you have. So the person who's going to have to handle this will be you as the executor. Let's take a look at some of the points of that. Once the court issues a letter and assigns you as administrator of the estate, you're going to have to mail notices to the creditors and you'll have to pay the debts. Many states actually have deadlines on how quickly you have to send these notices out. Let's take a look at what one of these notices to the creditors might look like. Here we have sample letters and notices. Request death certificate. Oh, okay, notification of death. Notification of death sample letter. Here's what it's going to look like. This is the subject matter. This is where you've sent it to. This is notify you of the death of so-and-so. Please update your records. You could actually add, if this person, if you are a creditor, please contact me at, and then here's your information. Once you've sent that creditor this information, and try to make it a certified letter to prove that you've sent it out, because the courts are going to want to know about that. The creditor has a certain time limit in which to respond. Otherwise, they lose all ability to collect credit. And that time limit can be found in the timetables. Expiration of notice to creditors. Actually, every state will have its own law, but usually within 120 days of you giving notice, notification, that's when the creditor loses their ability to come after you. Let me digress just for a moment back to something I said I was going to show you before. Remember I said you're going to have to get copies of the death certificate? Let's go back to sample letters and notices. And notice seeking will notification request death certificate. Here you go. Here's a sample. And you can go ahead and you send this letter out to the county recorder, who's in charge of keeping all the death certificates. But the easier way of doing this is you're going to be dealing with a funeral home. And one of the funeral home's jobs is to get a copy or as many copies of that death certificate as you want. Because you're going to be paying this funeral home a lot of money for services, and obtaining death certificates will be one of those services. Oh yeah, and get a lot of those death certificates, because most places that want to see a death certificate will want to see an original, not a certified copy. So you can get like 10 originals. And the final item on this checklist, and this is the person that's actually writing the will, not the executor. They need to head off disputes by explaining the estate plan to all family members and asking them to respect it. Many families that were very close together got ripped apart because of their conflict between who thought who should get what, etc., etc. the better job that a person does in writing their will and clearly stating who gets what will prevent people from arguing over it later. Well, that's about it. Let's see. Sit back, enjoy the fire, and try to absorb some of the stuff I just said.